still under oath?
Yes.
You're still under oath, but just for the jury's benefit, since you weren't here for the first time, we kind of went through this, could you state your name and spell it for the record?
My name is Seth Stoughton, S-E-T-H-S-T-O-U-G-H-T-O-N.
Could you tell the jury what you do for a living?
I'm a professor of law at the University of South Carolina, Joseph F. Rice School of Law, and the faculty director of the Excellence in Policing and Public Safety program there.
I guess I could split that up. Could you tell the jury how long you've been just purely a law professor at the University of South Carolina?
I'm just finishing my 11th year there.
And knew that, I didn't get the whole title, the policing aspect of it. What is that, and how long have you been the head of that?
The Excellence in Policing and Public Safety program is about 2 years old now. I've been the faculty director the entire time. It's a legislatively funded program in South Carolina to help provide training, professional development, and research and technical assistance to police agencies in South Carolina and beyond. We spent the last 2 years doing training of groups of police executives in South Carolina. In August, we will launch the country's first master's degree at a law school specific to public safety executive leadership.
Now, when you talk about training executive leadership for the police department, what is executive leadership defined as?
When we're talking about police executives, we're really talking about what's often referred to as command staff members. Exactly what that rank is will depend from agency to agency. At a very large agency, that might be captains or majors and deputy chiefs and a chief. At a much smaller agency, it might include sergeants or something like that. But if you think in terms of rank and file officers and sort of middle management, anything above middle management is really what we refer to as police executives or command staff.
Now, you're saying this is only 2 years old. Could you give a little bit of background? How did this get started? Why did it get started?
Sure. So I and some other folks that I work with at the University of South Carolina wanted to look for ways that we could bring academic resources at a top-tier research university to local policing. We already had pretty good relationships with local agencies on an individual basis. I do a lot of work with specific agencies, either assisting them with research needs or asking them to assist me with research needs. But we wanted to do something to sort of institutionalize and formalize that. In South Carolina, there is no executive level training, no professional development for police officers. We end up sending our police executives out of state to programs like the FBI's National Academy, and we wanted to develop some in-state capacity for that to help support the state and the community. So those discussions started about 4 years ago. We spent about 2 years putting together proposals and sort of refining what exactly we would be doing before getting the initial block of legislative funding in, I guess it was October of 22, and really launching in operations in January of 23.
And so you've been part of that process since the inception, working, who else are you working with? Is it just purely the university, or is it other entities in the state of South Carolina?
We have an advisory board that's made up of about 60 or 70% South Carolina law enforcement.
I'm going to object to developments of his knowledge of South Carolina law.
It's nothing to do with South Carolina law. It's who he's, this police training agency covers not just South Carolina, but other places.
So you're just asking him for background information?
Correct.
At this time?
I'm not asking an opinion on anything. It's just background information on what this is all about.
Okay, you said what this is all about.
The police training facility that he's starting up.
Okay. And Mr.
The relevance of him setting up a police training facility in South Carolina does not seem relevant to this matter.
Lays a foundation as an expert in this area if he's going to be talking about police practices.
Well, I mean, I would tend to agree as far as getting into detail about it, but the fact that he's setting something up is fine.
Okay.
So I guess I'm partially sustaining based on whatever the next question. You can answer that question.
The question I had, or the question?
What was the question that you just asked?
Just in terms of what was the purpose of setting this all up? What was the purpose of setting this up?
Oh, then I'll just sustain the objection.
Could you go a little bit of your educational background?
Sure. Let's see, in chronological order, went to high school in South Florida, went to Florida State for undergrad. I'm a little slower than the average bear, so it took me 10 years to get a 4-year degree. I went from there to the University of Virginia for law school, and that's it for formal education.
Okay. Now, in terms of after graduating the University of Virginia Law School, did you become a law professor right away?
No, not right away. I spent a year clerking, working for a judge. I was set to go back to a law firm in Charlottesville, but had the opportunity to do what's called an academic fellowship. The academic fellowship is really designed to help prepare you for entry-level legal teaching, to learn to be a law professor. It's kind of like a postdoc, but for JDs, for lawyers. So I did that for 2 years and then went on the entry-level market and was hired at the University of South Carolina.
Now, at the University of South Carolina, specifically, what do you teach there?
Within the JD program for law students, I teach criminal law, which is our first year required criminal law course. I teach a course on criminal procedure, which is fourth and fifth and a little bit of the Sixth Amendment. I teach a class called Police Law and Policy. I teach a class called Regulation of Vice, a seminar really. I have taught some other classes, but those are sort of my current teaching package.
Do you do something with the undergrad facility as well?
I have a courtesy appointment within the Department of Criminology, so I'll go over and lecture in coworkers or colleagues' classes. I have taught an undergrad version of my Regulation of Vice seminar with our honors college, but I have no real normal teaching responsibilities at the undergrad.
Now, in terms of your experience within teaching criminal law, criminal justice, and policing, have you done any sort of publications? Have you wrote any books, articles, anything along those lines in the field of criminal justice, criminal law, or policing?
Yes, that is the other half. I have about 4 different halves of my job. One of those halves is academic research and publication. Articles, essays, book chapters, 1 book so far, and the occasional other professional writings, editorials or amicus briefs and the like.
What is the 1 book so far that you've authored?
It's very creatively called Evaluating Police Uses of Force.
Now, in terms of, you say people ask you to write book chapters then for their own books, can you describe that a little bit more? What does that mean?
Sure. So there are academic books that are written by a single author that follow a sort of arguments or series of arguments. There are other academic books that are edited volumes of collected chapters where every chapter is written by a different author presenting something about whatever the overall topic is. So I've done book chapters on in a book about sort of law generally. My focus was on law relating to police misconduct around the world. I've done book chapters on evaluating police use of force incidents, on review and evaluation of police use of force incidents, on evidence-based policing and its applicability in modern policing, a range of topics.
And now, in terms of that, in terms of a lot on policing, do you have any experience in policing yourself, separate from your academic kind of credentials, any practical experience in policing?
I do, yes. I spent 5 years, just under 5 years, as a full-time officer with the Tallahassee Police Department in Florida, and then another 6 months or so as a reserve officer, a part-time officer at the same agency.
Do you do anything, I guess, currently, taken away from your new entity, do you do anything currently with any police agencies or police departments through your work in the law school or as a professor, or involved in that any way in any other police departments, if you will?
Not including through the policing program
Correct.
that I run? So not including through the policing program, I will occasionally be asked to come in and do training or to lecture on a particular topic. Once I have once I was asked to formally come in and investigate and review a use of force for, not actually by the agency, but by the city council of this city involving this agency. I'll be asked to come and speak in training that an agency offers not only to its own officers, but to other agencies. So the Washington, D.C. Metropolitan Police Department has a police leadership academy. It's a 3-week program, I think, and I come in and talk about use of force review for one afternoon in that course. In a couple of weeks, I'm going down to Charleston, South Carolina, where the Charleston Police Department has its own police leadership academy, both for its own officers and officers in the area. So I'm sort of guest lecturing as one of the talking heads in that program. None of which is formally through the policing program that I run.
So those are your people are asking you to do that, and then a lot out in South Carolina, is that just in South Carolina, or do you go across the country doing that as well?
Sort of where asked, as long as my schedule works out. I've done it in DC twice, Kansas City, back to DC for a different agency, Charleston previous, and that's in South Carolina, kind of wherever time and schedule allow.
Do you belong to any groups, any outside organizations in terms of involved in policing and police review institutes, for example, the American Law Institute?
I do. I am a member of the American Law Institute. I was an advisor on a project of the American Law Institute called Principles of the Law Policing that actually just got released in final form after about 8 years of working on it. I am a member of the the American Society of Evidence-Based Policing, the International Association of Chiefs of Police, and the Legal Officers section. I think I still have an active membership in the Police Executive Research Forum. I think that might be it for police-specific organizations.
Now, in terms of your work, you're outside kind of law professor, do you get hired, brought in to review use of force incidents involving police officers in specific cases like this one?
Yes, I do.
Can you give the jury an idea how many times you've been asked to do a review similar to the one you did here?
I've been formally retained 130 or 140 times, somewhere around there. I can't even count. I do not keep a track of how many conversations that I have that may not lead to retention, so there are some number of other phone calls or emails or exchange beyond those where I do not end up getting retained for whatever reason. Most of those are litigation related, either civil or criminal litigation, a combination of plaintiff side or civil defense or prosecution or criminal defense. There are some non-litigation retentions where it's sort of strictly a consulting capacity, usually as a subject matter expert through a federal grant, a Bureau of Justice Assistance grant or something like that.
Have you testified then as an expert in any of those cases that you've been retained on?
Yes, I have.
How many times have you testified in a courtroom like this?
In court, in trial, somewhere in the area of 24, 20, 24, or maybe a little bit more than that. Deposition testimony is even more than that. I don't know off the top of my head, probably twice as often.
And in those instances you testified, you've been qualified as an expert in use of force and police practices?
Yes, I have.
I'd move for this time to have him introduce his testimony, introduced as an expert in use of force and police tactics, police practices, excuse me.
No objection?
Not to those areas, Your Honor.
All right, so he shall be considered an expert in those fields.
Can you give the jury an idea of approximately when did you get involved in this case and what goes into getting involved? What did you review when asked to review a police use of force case like this one?
Yes, you're asking me the hard question, which is about timeline. I don't even remember the timeline that I got involved. I could try and look at my retention agreement, that would remind me, but it would be right around there. So I don't advertise as an expert. I don't have a website or business cards. I basically get emails or phone calls from other folks who have passed my name around. I forget if the initial contact here was an email or a phone call, but it was one of those things that asked to set up a conversation about whether I could be potentially useful in this case.
Now, in terms of when you decide to take on a case, what is your process? What do you do? What do you look at?
So the first and most important thing that I look at is whether I am an appropriate expert in the case. There's a lot in policing. There's a fair amount in policing where I wouldn't want to be testifying about technical expertise in an area that is not covered by my research or experience. With tactics and use of force, those cases are pretty sound. That's well within my wheelhouse. Sometimes with other cases, that's an easy way for me to weed out retentions. Probably the next thing is looking at my schedule and making sure that I can do the work that needs to be done in the timeline that it needs to be done on. Sometimes that will involve a preliminary review where I look at maybe 20 minutes of worth of material, a short video or something like that. We did not do that in this case, as I recall. I think we had a preliminary discussion and then engagement, and then I'd actually start the review. I get the body of material that is shared with me and start the review process.
Before we get into it a little bit more, you talk about tactics and use of force being kind of in your wheelhouse. Could you describe to the jury what you mean by, first off, what are tactics? What are tactics that are in your wheelhouse? What do you mean by that?
Sure. In the policing context, tactics are how officers navigate and mitigate potentially risky situations. It's the decisions, the procedures that officers use to help keep themselves safe, and because they are safer, the community members that they're interacting with are also safer. There are a couple of different definitions of tactics, but they all come down to making a decision to balance competing priorities in a way that allows officers to achieve whatever the police mission is in that individual interaction in the safest manner that the situation allows. There are a bunch of different kinds of tactics. I'm sure we can get into some of that, but sort of as an overview, tactics are just how officers manage risk and prevent risk from escalating to the point of being a threat, or a threat from becoming a full-blown actual injury or harm of some type.
And what about the use of force? You kind of separate that out. What does use of force mean to you in this aspect?
Yeah, in the way that I'm using that term, use of force is really about the application of coercive physical force. So the easy one is shooting someone, punching someone. Sometimes you'll get some different definitions where use of force might be just communication. When I'm talking about use of force, I'm talking about hands-on physical engagement with someone, either with weapons or without weapons, the use of coercive physical force.
Now, when you talk, then we start again into, you take a look at all the materials when you're reviewing a case. Can you give the jury an idea of what materials you reviewed when looking at this case and what occurred here?
Sure. At a very high level, there were 3 videos. There was a dash cam, a body cam, and a bystander cell phone camera. There was an investigation and documents related to an investigation. There were some agency policies and procedures, some training documents. I can probably get more detailed if needed, but that's an overall summary.
And so you take a look at you get all that together. Now, in this instance, I also want to clarify, this was kind of a joint report with Nick Bloomfield, correct?
It was, yes.
How do you do a joint report? How is that different? Is that something you normally do?
It's not common, but it's not uncommon either. I've had a couple of cases now where I've done a joint report with another expert. The process does not really change at all. The only thing that changes is after we review the materials and develop opinions, is coming together and make sure that the report that we submit has opinions that we both agree to, and that we don't have any internal points of disagreement that would require an addendum or additional reporting indicating our points of disagreement.
So for the jury's benefit, you get a look at the body cams, you get all the materials, the investigative materials. Could you give them an idea, what do you look for? Okay, what is going through your mind in terms of reviewing a force? You know, what happened here? What criteria do you use, I guess?
Sure. So the first thing is I have to know what actually happened, right? So the first thing that I do is review the materials to get an understanding of the facts. It's a little simplistic to say I watch the videos and read the reports. It's a little bit more like I watch the videos, I read the reports, and I compare them to each other to identify points of consistency or inconsistency, to identify where there are still lingering questions that the body of evidence doesn't actually solve, to identify discrepancies or issues where two different witnesses might say two different things, right? As an expert, it's not my job to figure out who is telling the truth or figure out which discrepancy is accurate or which piece of evidence in a discrepancy is accurate or inaccurate. So normally what I do in cases like that is I just make note of this discrepancy and say, hey, there is, this person said X, this person said not X, right? Said something different. Once I have an understanding of the facts, then I try and identify what the different decision points were. That is where an officer made a decision. And as you can imagine, there might be dozens of those decisions that an officer makes over the course of an encounter, right? With each decision, I'm looking at the decision to see whether the decision, and that might be a tactical decision, it might be an enforcement decision, like do I stop this person and chat with them or not? It might be a use of force decision. What I'm looking at is whether that decision was consistent or inconsistent with generally accepted principles and practices in policing. Does it meet that sort of professional degree of commonality that we expect professional officers to be able to meet?
Can you go into that a little bit more? What exactly is generally accepted police practices, and what does that mean to you and for the jury's benefit?
Sure. Again, this is a little colloquial, but when we're talking about generally accepted principles and practices, and I can define those two things separately, if you went to a reasonably well-trained officer at any agency, pretty much anywhere in the country, and you said, is this more or less the way you do things? If they say, yeah, that's more or less the way we do things, that's probably a generally accepted practice or generally accepted principle. This is a little bit tricky in policing because we don't have a single authoritative body in policing that sets out what generally accepted principles and practices are, right? In accounting, there's something called the generally accepted accounting principles, and all accountants have to use that. We don't have that in policing. We have about 18,000 different police agencies across the country, some very, very small, some very, very large. So when we're trying to identify generally accepted principles or practices, we're asking what has sort of bubbled up from below. What do all of these agencies, what do officers do? What is common and generally accepted as the standard for professional policing across agencies? You can find information about generally accepted practices reflected in an agency's policy manual. You can find it in statements or publications by police organizations like the International Association of Chiefs of Police or the Police Executive Research Forum or the National Police Foundation. But it's not authoritative because the International Association of Chiefs of Police said it. It's easier to flip that and say the reason that the International Association of Chiefs of Police is saying that in something like a national consensus policy or national consensus paper on use of force is because it is so common that it is generally accepted.
Now, can you get into a little bit in terms of what factors do you consider when you're looking at an incident? What are the factors as an expert you consider when reviewing tacticals or police use of force? What are some of the factors
Sure.
taking into account everything?
The ultimate question for tactics when I'm reviewing them is really what are the tactical risks of what the officer is doing and what is the benefit of what the officer is doing, right? Officers, as one resource puts it, officers work in risk soup. They're constantly in situations that are dynamic and maybe uncertain. So they have to make this series of decisions without fully accurate information. So what risks do they take and what risks do we say those are not professionally appropriate risks anymore? As that phrasing sounds like, it's very, very heavily fact dependent, right? There are situations that will absolutely justify officers putting themselves in grave harm, like an active shooter situation where we now train officers to run in and identify that active shooter to deal with the situation. There are other situations where that degree of risk-taking would be inappropriate or unjustified, right? Where we don't want officers to unnecessarily take risks. And the way we determine whether an officer is taking a risk appropriately, professionally, or unnecessarily is by basically looking at what's the tactical risk, what's the tactical benefit, putting those two things together, does it make sense? When I'm answering that question of does it make sense, that's not me as, Seth thinking, do I think this makes sense? That's where looking at generally accepted practices, looking at generally accepted principles across policing, applying that framework. Does policing as an industry, does policing as a profession think that this is a professionally appropriate risk or not a professionally appropriate risk?
Now, you touched on it a little bit in terms of running into active shooters. What role does the threat against the officer play? Does that play a role in any of your analysis?
Yes, it plays a huge role, particularly as we shift from sort of the tactical question to a use of force analysis. So when we're analyzing use of force, we're again looking to see what the officer is trying to accomplish, but there's a slightly different framework for that. So officers can use force to deal with imminent threats, and I can define that term in a second. But when they have a situation that does not yet amount to a threat, but might still become dangerous, it's a potential threat, that's what we refer to as risk. So as sort of a rule of thumb, officers use tactics to navigate risk. They use force to address threats. And in policing, a threat exists when the individual that the officer is interacting with has the ability, the opportunity, and the apparent intention to cause some kind of harm to the officer or others. I can define those terms if it's useful.
I guess you could, because you talk about imminent threat. What you said imminent, is that the definition of imminent threat then, in terms of the ability and so forth?
In policing it is, yes. You will sometimes hear immediate instead of imminent. You will hear some commentators sort of distinguish between those two things. For my purposes and most experts, the important part is there an imminent threat? And an imminent threat exists, or if you like, a threat is imminent and thus justifies a use of force when the subject has the ability, opportunity, and intention to do something, right? At that point, there is a threat of something that may justify a use of force.
Can you go a little bit more detail? What is the difference between imminent, or what is an imminent threat, and maybe something that's just concerning?
Sure. Yeah. So really this focus on ability, opportunity, and intention. Again, I don't want to get too carried away with specific language, because it's really the concepts more than the words. Sometimes you'll hear ability, opportunity, and jeopardy, or you'll hear ability, opportunity, and threat, or some combination, but it all kind of means the same thing. When we're talking about ability, we mean the physical capacity to cause whatever type of harm we're talking about, right? If an officer is interacting with someone who doesn't have anything in their hands, then that person might have the physical ability to hit an officer with a fist, but doesn't at that point have a physical ability to swing a weapon, as opposed to someone who's holding a tire iron. Now that person has the physical ability, the capacity to hit the officer with a tire iron. When we talk about opportunity, we're really talking about, is anyone vulnerable to that particular type of harm? If someone has that tire iron and they have the physical ability, but they're 60 feet away, they don't have any opportunity to hit anyone. They might if they get closer, but they don't yet. On the other hand, if they're within arm's reach of an officer, there is ability and there is opportunity to now use that tire iron as a weapon. The last prong is apparent intention. Does it look like the person is trying to do that thing, right? From the officer's perspective, does it look like the person is going to do that harmful act? So someone who has a tire iron that's within arm's reach of an officer, but they're chit-chatting on the side of the road while the guy changes a tire, might be a situation of risk. The officer could say, sir, why don't you put that tire iron down? Or the officer could back away and use distance as a tactical concept. Or the officer could interpose a vehicle between himself and the subject. But there's no threat, because the subject doesn't look like they have the intention to use the tire iron as a weapon, as opposed to someone who is swinging the tire iron at the officer or cocking back as if to swing the tire iron at the officer. At that point, we have ability, opportunity, and intention, which means we have a threat that justifies the use of force.
And so that use of force, it covers the spectrum in terms of, could be throwing a punch all the way up to deadly force. It's kind of the same analysis then?
It's exactly the same analysis. We're still looking for an imminent threat of something. And that's really important because there's no such thing as a threat. It's always a threat of something, a threat of escape, a threat of being injured, a threat of being seriously injured or killed or something like that. What's different with different types of force is the next sort of question. If there is an imminent threat such that some use of force is justified, then we ask, okay, what kind of force would be justified here? If it's a very high-level threat, it tends to justify a higher-level force. If it's a very low-level threat, then it justifies a very low-level force. In my world, this is referred to as proportionality, right? The use of the use of force has to be proportional to the threat. So the way that we do this analysis is first asking, what is the nature and severity of the officer's use of force? Then asking, what is the nature and severity of the threat that the subject presented, if any? And then once we answer those two questions, we weigh them against each other and identify the relationship between them to determine whether, as a matter of generally accepted principles or practices, policing would define that as proportional or not.
And in terms of, there's a reasonableness figure into that. Is that proportional? Is reasonableness and proportional the same thing, or is reasonableness a little bit different? Do you use that differently?
It's effectively the same thing. Policing has adopted into its generally accepted principles the term reasonableness, which ultimately it sources from law, both Fourth Amendment law and state common law decisions. Incidentally, that's also where concepts of ability, opportunity, and intention come from. Those ultimately originate in common law doctrines related to assault, but policing as an industry has accepted those as the practices and principles within policing.
So when you look at using the term reasonableness, does reasonableness come into play? You talked about intent, a motive, and opportunity with a person the force is used against. Does reasonableness pertain to the officer then more? Is that, you use that distinction, if you will?
Yes, I am looking at applying this framework. That is a framework that we use to analyze an officer's decision making, right? Is the officer reasonable? Is the officer consistent or inconsistent with generally accepted practices? We have other frameworks to assess the other person, right? We might ask, did the other person commit a crime, for example, by doing whatever they did to the officer? But the frameworks that I'm talking about, and my role as an expert, I'm analyzing police actions, not subject actions.
So I guess getting kind of to the meat now in terms of looking at this incident specifically. Did you come to any conclusions in terms of different types of actions that were taken by the defendant during this interaction with Patrick?
Yes, I did.
I guess starting off the first thing, starting off with what happened at the beginning. What were your conclusions?
So again, I'm looking at all of the decisions that were made. The sort of initiating decision here, the first level decision is the decision to stop the car, to initiate a traffic stop. Generally accepted in policing that when officers have reason to believe that there is a traffic infraction, that you can stop a car. My understanding is that there was an improperly displayed license plate on the car. That's a traffic infraction. So stopping a car for that reason is consistent with generally accepted principles and practices in policing.
So a reasonable officer in that circumstance would have done the same thing?
Yes.
What about your next analysis?
I believe the next opinion related to Officer Shore's attempt to grab Patrick after he got out of the car and began to walk away. That use of physical grabbing, it's a use of force. It's a relatively low-level use of force. Comparing, again, the nature and severity of the officer's use of force, which is relatively low risk. That is, when we're identifying nature and severity of force, we're really looking at what is foreseeably likely to happen, and just grabbing someone is not foreseeably likely to do very much, so it's a fairly low-level use of force. nature and severity of the threat that Patrick's actions presented there. He's walking away. There's a threat of escape or evasion. So balancing those two things together, grabbing someone who's attempting to walk away, is perfectly consistent with generally accepted principles and practices in policing.
So a reasonable officer in the same circumstance would have done that.
Sure.
What about the decision to chase him around the car? What about that?
That's where we start to run into issues. So they run around the back of Patrick's vehicle and then past the front of the vehicle, sort of along the sidewalk into that driveway area. This creates some tactical concerns. And the reason it creates some tactical concerns is because there is another individual in that car. And in policing, the goal is not just catch whoever runs away. The goal is to do so safely and efficiently. And if you run past a car, you don't know what else is going on with that individual in the car, what else they may be doing with any evidence that might be in that car. So if one person goes hightailing off and you chase them, you may miss the fact that the other person is taking all of the evidence out of the car and walking away and dumping it somewhere. You also expose yourself to some unnecessary tactical risks. When you run past the car and now you have the other individual in the car at your back, you have no idea what they're doing because you're so focused on the individual that you're chasing. And that gives them an opportunity to, put it bluntly, get out of the car and attack you in a direction that you were not expecting. So going back to that sort of tactical framework, the tactical benefits of chasing someone are not nothing, right? There is some tactical benefit that I could chase someone and maybe grab them. But the tactical risks of doing so are substantial. And for that reason, there's generally accepted guidance in policing that says if there are more people in the car and someone goes running, you stay with the car. There's a pretty good chance that you're going to be able to identify whoever ran by talking to the people in the car. That gives you the opportunity to collect any evidence in the car. And if you can identify them and collect evidence by talking to the people in the car, you just get a warrant and catch them later. Doesn't mean they get away scot-free. You just may get them, later that day or tomorrow or something.
Now, when you say generally accepted police practice, specifically on foot pursuits, what is there anything, a background, if you will? What sort of things you're relying on to say that is a tactically bad decision?
Sure.
For a reasonable officer?
Yeah, so there's now a lot of guidance on foot pursuits, including from the International Association of Chiefs of Police, the Department of Justice, and others that have pointed out that foot pursuits are an indication not just that someone is trying to escape, but that someone is more likely to resist at the end of that foot pursuit. If they're already running, they may try and push you off of them. Or they may even be, direct violent or assaultive action toward the officer with their attempt to escape. So because of that reason, even ignoring someone else in the car, the general guidance in policing is that when you are chasing someone on your own, you do not actually want to catch them until you have another officer present, right? You want to keep them in sight until there are additional officers on scene so that, to put it bluntly, so it's not a fair fight, right? You don't want it to be a fair fight one-on-one. You want the officers to outnumber the person that they are attempting to take into custody. When you add other people in, and like the person sitting in the car, again, there are tactical considerations beyond just catch the person who is running, like the ones that we mentioned. So the International Association of Chiefs of Police, for example, reminds officers that they have to consider that totality of the circumstances, including other people who may be running or who may not be running, but may choose to involve themselves in the scuffle after that.
So then look, kind of the next step, and I wanted, because Nick's going to testify tomorrow, or maybe later on today, depending on how things go. I want to kind of go over skip over the taser, leave that for him.
Sure.
In terms of following up the next aspect. Did you have an opportunity to take a look at Grand Rapids police policies and procedures as part of your analysis of all this?
Yes, it did.
Okay. I'm going to show you what's been entered into evidence as Exhibit 32. You recognize that?
I do.
And in terms of that document, that's one of the documents you reviewed as part of your analysis of this case.
Yes.
I think maybe it's a second or third page on that. There's policy changes, if you will, 2020 policy changes.
Yes.
Is that on page 3 or 4? Can't remember.
Policy changes is on page 4 here.
Okay.
I don't mean to interject, but didn't we have everything match what the professor is? Can I get a copy of exhibit 32?
Would you like to look at what he has on his
Yeah,
page?
just to kind of confusion. There. Thank you. Thank you, I'm sorry.
Reach the right spot.
Thank you.
So the 2020, there are some changes, I guess, in terms of 2020 in regards to police, specifically Grand Rapids Police policies and procedures, correct?
Yes, that page says GRPD at the very top. GRPD use of force policy changes 2020.
Now, in terms of the policy changes, was there any direction in terms of giving a warning before using deadly force?
This is number 3. Number 3 says require a warning before shooting, and then goes on MOP 9-1.64. Whenever reasonably possible, officers shall provide verbal directives before deadly force is used.
Now, in terms of, you knew that, did that factor into your analysis in terms of when you're trying to make a decision on the use of force, the ultimate use of force, which you're called in for in this case, did that play a role in your decision?
Sure, yeah. In sort of 2 ways, right? One, everything that I looked at factors in, right? Everything in the case file factors into the decision making, even if it ends up not being dispositive. In this particular case, one of the opinions that Nick and I developed after reviewing the materials is it would have been feasible in this case to give a specific warning about the use of deadly force prior to that use of force.
And why is that?
Why was it feasible, or why is that? Because there was time to do so. There are at least several seconds prior, even while Officer Shore is reaching for and drawing his gun, that would have allowed for a specific warning about the use of deadly force.
Now, in terms of that, you've talked about generally acceptable police practices. Does this policy also reflect that, if you will, in terms of, is that something that's required now, or at least across the country?
It does, yes. So it is certainly a generally accepted practice now that officers give a warning, and I want to emphasize when feasible, because the situation does not always allow for it, but that officers give a warning when a warning is feasible, when it is reasonably possible to give a warning. It's generally accepted in policing that they should give a warning prior to using deadly force. That actually got incorporated into generally accepted police practices after a Supreme Court decision in 1985 that sort of made the same point. Now, that was in a legal context, but police practices adopted it as a generally accepted principle or practice within policing.
Now going into a little bit further in terms of, I guess I'll go right here. Can I use the video? Some of the stuff that we're introducing are procedures by the GRPD. We don't want to put those on for the media. These are policies that are already out there in the open, so I'll refer directly to them. This is still part of Exhibit 32.
Sure.
We're looking at 9-1.1. Since you're here, looking at paragraph 3. Do you see paragraph 3?
I do, yes.
And this would be the use of force policy, if you will, for Grand Rapids Police.
Yes,
And you reviewed that?
I did.
What are your thoughts? As an expert, is this generally what's out there for other departments? Is this sufficient? Can you give an idea how this factored into your decision?
So this is a pretty casebook reflection of generally accepted practices in policing. Policing limits the use of deadly force to those situations where there's an imminent threat of death or great bodily harm. Policing typically says that there are two ways that can happen. One is immediate, one is through escape, and you see both of them sort of outlined in B3 there. Again, the wording might be ever so slightly different, reasonable threat instead of imminent threat, but the concept is certainly is reflective of generally accepted practices in policing.
Going down now to this is 9.14. I don't want to shrink it too much. You can see it just a little bit at the top. 9-1.4.
Okay.
You have another definition of deadly force under C.
I'm going to, I want to object to the record. The policy that the witnesses testified about is from 2017, and the policy that was in place may be very similar, but it has not been established that this policy was in place at the time of the incident. So he's testifying about something that's completely irrelevant.
I think this is the same policy that they were trained on. This is part of the training that was given to the officers at the time, so they can rely on it.
At which
So,
time?
this was back, I don't have the thing, this is 2020, that policy 2017 at the bottom, but this was also given in 2020. So this is still part of the same policy, and this is part of the training that was given to Officer Schur through his career.
Yeah, there's a policy from January 19, 2021 that came from GRPD. It may be very similar, but there may be differences.
But these are already admitted, Your Honor. These are already admitted, Your Honor.
Right, is that admitted as an exhibit?
It's already admitted as an exhibit, so
This one is admitted, the 2017 policy has been admitted.
Okay.
But
And so
it
your
is not,
objection
it's
is-
relevant. What does it matter?
Are you saying that the exhibit's not relevant?
Right.
But it's
Well, I'm
already
saying his
admitted.
testimony is not relevant. I didn't know the relevance.
So his testimony about an admitted exhibit, I would think would be relevant because it's already admitted. To the extent that it's different, then obviously that would be something you can admit if there's a newer, different policy. You can certainly move to admit that, but because was admitted without objections, it's
And
already
also,
in evidence, so.
if we could get some explanation for why this witness who is not an expert on the GRPD policy, if it provided the basis of his opinions, then I don't know if that's going to establish either. So that's more of a foundation.
that's what I just asked him. In terms of what,
That he's an expert on GRPD policy?
no, what role did this play in his decision?
Okay, so I'll allow him to answer that question. Maybe it didn't play any role because then that would be a kind of a moot point. So I guess he can answer that question, but again, I can't say that the exhibit's not relevant or that this witness's testimony regarding an admitted exhibit is irrelevant because he can only use the facts that are in evidence and information that is in evidence and the exhibit is in evidence. So you may answer that question if you're interested.
Could you ask that question one more time?
Just to
Sorry.
say, this was one of the things you reviewed as part of your analysis of this entire case.
Yes.
And looking at 3C, they talk about objectively reasonable control of the situation. Is that a term you're familiar with? It's 3C under 1.4.
Yes.
What does objectively reasonable mean to you?
That is the phrase in policing that is the generally accepted standard for police uses of force. They must be objectively reasonable. That language, generally accepted in policing, after policing adopted it from a 1989 Supreme Court case.
And so that's part of the analysis, not only for GRPD, but that's something that you're familiar with and used in your analysis of this case.
Yes.
once again, looking at, now we're down to 9.15.
I'm sorry, what page are we on?
Then the page there, it's just policy 9-1.5.
Page 10 of the PDF, or of the,
So in terms of the totality, you talked about the totality of the circumstances. What does that mean to you? And I guess how is it reflected? Is this, what's reflected in their policy reflective of what the totality of the circumstances mean in generally accepted police practices?
yes, so totality of the circumstances here when you're analyzing use of force, it means you look at all of the facts and circumstances that the reasonable officer on the scene would have been aware of, the facts and circumstances that were available for an officer to observe and draw conclusions from. We want to avoid artificially limiting that, because ultimately an officer should be basing their decision on the information that's available to them. And there's some information that is maybe potentially relevant, and there is other information that's far more likely to be relevant, right? So for example, like the phase of the moon is not particularly relevant to a use of force. It might be relevant if it happened at night and we're talking about ambient lighting conditions. Ambient light is part of the totality of the circumstances. What I see this list of 1 through, it goes down to 15, as is a summary of relevant or potentially relevant factors that can make up, don't necessarily, because they may not be present in every case, but they can make up the totality of the circumstances that we review in determining the threat that the subject presents and whether the officer's use of force is proportional to it.
And so this listing here for Grand Rapids policy is also what is used out in the generally accepted police practices as well.
Sure, you don't always see it as a list. In our book, my co-authors and I provide a similar list. We break it up into 3 different aspects: a list of officer characteristics, a list of subject characteristics, and a list of environmental or situational characteristics. But they're all basically the same, right? I'm not saying like this exact list is something that you can find in every agency. But again, if you talk to officers at every agency and said, could this matter in the use of force analysis, they'll say, yeah. And there's probably stuff that's not on this list of 15 that could also factor in to the use of force analysis, like ambient light conditions, which are not actually on the list.
Why would ambient light conditions? That seems like kind of a random thing.
It depends on what an officer can see or can't see, right? How well an officer can actually see what's going on and what conclusions they draw from either good visibility or limited or bad visibility. That can definitely matter.
And did that one thing, going back to the 2020 changes, going back to I think page 4,
Yes.
the things we can't put on.
Page 4, I'm there.
Was there anything about reasonable alternatives being exhausted before use of deadly force?
There is point 4 says require that all alternatives be exhausted before shooting, and the note is already in MOP 9-1 under escalation and de-escalation of force.
So all reasonable alternatives exhausted before shooting, is that a generally accepted police practice?
This one gets a little bit tricky. In most contexts, yes, but we have to be careful in how we define reasonable alternatives, right? In the context of a shooting, officers are presumably using deadly force to address a threat, as mentioned elsewhere in that policy, to address an imminent threat of death or great bodily harm. So we don't, when we're talking about reasonable alternatives, we're not asking, is there something else that officers could have done? We're asking, is there something else that officers could have done that would have had a similar likelihood of addressing the imminent threat of death or great bodily harm? So as long as we sort of define what we mean by reasonable alternatives, yeah, that's fairly common.
So ultimately, this comes down to the decision to fire on the cell phone video that you watched, correct?
Yes.
Can you give your idea? Was the decision with a reasonable officer similarly situated made that decision?
Objection, Your Honor? Let's see. Can we approach?
Yes.
to please leave your notes upside